How to Get Divorced in Ontario Family Law Basics for those just getting started. By the time this video ends in just over 20 minutes, you will have a legal toolbox of valuable knowledge and resources that you will return to over and over again. This course acts as a roadmap for your divorce journey ahead of you. It will empower you to make better decisions, to file your paperwork in less time with less mistakes, which can result in decreased stress and significant cost savings. You need to know you're not alone, and you need to believe that it's going to be okay. Our actions, even small ones like taking this course and beginning to educate yourself, can have significant consequences. This is called the butterfly effect. My name's Lorraine Lawson. In the years of coaching, the biggest mistake my clients admit to making is not doing their homework. They fail to understand the legal system and how it operates. If you are willing to commit a few minutes to educate and empower yourself, this will change the trajectory of your legal matter. It is key to keep educating yourself. Let's begin with understanding the 5 different courts in Ontario. The first is SCJ, Superior Court of Justice. This court handles divorce, property support, decision-making, and parenting time. It is federally mandated. The Ontario Court of Justice is provincial in nature. It does not apply when there's divorce or property settlement, but it does apply when there's support, decision-making, and parenting time. In this court, the judges are primarily from a family law background and are trauma-informed. They deal with CAS cases, etc. The Unified Family Court is a combination of both courts, and the lawyers here become the judges. They may have a background, corporate or family law. So there really is a varied variety of judges in the system. The fourth, the Court of Appeal, and the fifth, the Supreme Court of Canada. At times, you will be asked to identify the region that your court lays in, and here's a map that will help you to be able to answer that correctly. You can note that Toronto has its own regional court. Why do you need to know this? And it's simply so you can choose the proper forms when you are going forward on your matter. The family law forms are often being changed. These are the updated forms, and this is really the only source you should get them from because these are the most current formats. They are located at ontariocourtforms.on.ca. In understanding the legalities of the system, there's 5 pillars of family law. The first are the acts. In federal, we have the Divorce Act, which underwent a sweeping change in 2021, removing presumptive 50-50 parenting and instead replacing it with best interest of the child. In regards to best interest of the child, the new Divorce Act also identified the fact that the judges are mandated to consider domestic violence in choosing parenting time and contact. This has been transformative. Provincially, there are other acts such as the Family Law Act, the Children's Reform Act, etc. The rules. Number 2 is the rules. These are very, very important. I suggest you print them, you read them because your future does depend on these rules. Number 3, guidelines and directions, support calculator guidelines, guidelines around court appearances. The fourth pillar of family law is case law, and this can be found in canlee.org. This site is a wealth of information and fascinating reading. This is where the judges talk about the situations they were dealing with in the court matters, all the cases that they're referring to from previous decisions, and they explain in detail why they made decisions they made. This is very good insight into the analytical thinking of the judges. This is how you're going to sell your position to the judge. The fifth pillar of family law cannot be overstated. It is the concept of negotiation. And despite how high conflict or calm your matter is, negotiation is one of the most underrated and understood pillars. It's what case conferences are about, settlement conferences, mediation, everything results in negotiation. And the courts are not fooling around on this. Family Rule number 17 talks about there's an actual requirement for parties to confer. And if you are not conferring, they spell out some of the repercussions of that. There could be an order postponing the conferences until the requirements are met, or an order for costs, regardless of whether the conference is postponed. Are there fees in the courts? In Superior Court of Justice, yes, there are. In Ontario Court of Justice, no. But you can at times have them waived if you make the appropriate applications. So let's talk about practice directions. What are practice directions and why they're so important? These are often overlooked by those self-representing, but they are very essential that you familiarize yourself with these. Here is how you find them step by step. The first is to go to ontariocourts.ca. From there, you will select your court that you are dealing with based on what we talked about previously. Head on down to the bar, the red bar that says Daily Court Lists Online. Direction link will open up, and there you have it. It's important to read these directions because if you are not following them, your case can go sideways, just simply over that. Like I previously mentioned, these will describe page limits on conference briefs, what you can include in your filings, and how to present your evidence to the court. For example, it spells out don't include pages and pages and pages of emails. Just pull out the relevant sections that you want the judge to be aware of. Same with text. If you have pages and pages of back and forth text, just pull out the individual text that you want the judge to be aware of. In this situation, you can tell that it's clearly important to have a concise story, and your evidence is to follow this. It's also important to appreciate that the other side can pull out the smallest little thing to make you look bad in front of the judge. So keep your plate as clean as you can. Now, for the other party to take you seriously and for your chance at being more successful at court, it really is better to look like you know what you're doing, even if you don't. And the way you present your evidence and follow the practice directions helps put you in the better light in front of the judge. This may seem already overwhelming, but step by step, as you take this in and you practice and you learn more, you really do have the tools to get moving forward and be your best advocate. Now that you've done this, how do you get a court order? Well, there's 4 ways to get a court order. One is on consent, and again, that relates back to the concept of negotiation, mediation, arbitration, collaborative law, through a case conference or settlement conference. The second way to get a court order is through motion. This is the most common procedure, occurs only after 1 or more conferences in most cases, and there are times you can apply for an urgent motion in the courts. The third is going to trial, but this is very, very rare. It involves many steps and brings a third parties in as witnesses, experts. It's very expensive, $40,000 to $50,000 in Ontario, and the orders that come out of the trial have the same power as those obtained in motions. Brand new to the courts in 2025 is a fourth option to get court orders. This is binding arbitration from a judge in a single session. This is being followed through Rule 43, and it requires significant paperwork because the judge wants to be able to take a glance at everything that has occurred and have it all in front of them as they move forward. Clearly, this means your paperwork needs to be very, very strong. You can have signed expert affidavits and different elements like that. And it's important to understand Rule 43. There are some risks and benefits of taking this route when you're dealing with a high conflict individual, especially if that individual is patterned to be putting a significant amount of lies into their documents. Because once the judge sees it, they cannot unsee it. So, developing credibility can be challenging based solely on paperwork. Essential to take comfort in knowing that the steps to follow in each of the processes of family law can be learned with a little bit of research and taking the time to follow the links. Simply using Google will land you with an array of information, and there's little links beside Google's answer that you can follow to see the source where this information was pulled from and follow up to make sure it's accurate. There's also other helpful online tools that will help you in Canada. And in Canada, the premier source here is called Steps to Justice. This will be your new best friend. When we're talking about the very basics of the very first aspect of going to family court, it's important to understand that the first form is Form 8. This is called an application, and in it, which is 5 or 6 pages in length, it contains a section called claims. This is the most important aspect of your family matter because everything under the claims says to the courts, this is what I'm seeking. For example, spousal support. Even if you don't know that you may follow through and ask for spousal support, if you don't check this later on down the line, you can't change your mind and go back and ask the courts for spousal support. So if you don't select a section, you cannot add it later without an amendment. This is important. So if you think it might come up and it's something that's relevant to your case, check it. This is not an easy or straightforward form. This is a good time to consult with a lawyer if you haven't already. At times, if you don't qualify for legal aid, there are some pro bono services here, there, asking different courts, but you can also consult with a lawyer on a task-by-task basis. This is called unbundled services. It's commonly known as a limited scope retainer. You will need to complete financial forms. These forms might be 13 or 13.1, and these differ between what you require from the courts. There's also a Form 35-1, an affidavit. Again, it's important to seek legal advice on how to complete these forms. This application is the foundation of everything moving forward for your family law matter. These forms might seem completely overwhelming at first, and they should because they're important. But the most empowering thing you can do for yourself is to sit in your confusion and overwhelm, but not let it take over. Know that you can fill out these forms line by line, minute by minute. It can and will get done. Be patient with yourself. Millions, literally millions of people get divorced and have sat in the exact place of fear. And even so, the paperwork gets done. And you can do this. Just a sidebar on your application, it's important to know that once you fill out these forms, if you are the first to file into the court, you will be called the applicant. In this matter, in the next motion, in trial, you will always be the applicant from start to finish in this matter. This stays the same in your process. The other party, your soon-to-be ex-spouse, will always be referred to as the respondent. There are 3 ways to file, but these are always changing. Currently, in person, is now becoming more limited and usually only available to those self-representing. Email also very limited, but online is where the push is going to file all your documents. Online can be a frustrating system. You can file your documents, you wait 3 to 5 business days to hear back, and in most cases, your first or second attempt will result in a rejection. So it can take quite some time to get your paperwork actually accepted into the system. But for this first matter, for this first application, the beginning of your family law matter, it may result in cost and time savings if that first application is made in person. If you're heading to the courthouse counter, take 2 copies, one to be filed and one to take home with you. Make sure you ask the court to stamp your copy, and you can leave with that. Because if you receive a document from the other side that is not stamped, this could be a trick or trap or a way they're going to bully you. This means that they've created the documents, but they have not yet filed them with the court. And if you have a lot of fear about going to court, they will get you into negotiation based on this fear. This initial application, again, Form 8, 13, and 35, needs to be served according to Rule 6, which says special service is required. You only have to do special service once. And that means it needs to be handed to the person and make sure that person is identified. Often the easiest and safest way to do this is through a process server. They will follow up with a signed affidavit of service, which you definitely want to keep in file. A relatively easy process costs anywhere from $80 to, I hear, $150, depending on several factors, location, number of attempts, but this can be money well spent. After the initial process, most court documents are now filed online. I don't go into that in this course, but the steps to follow can be found on the Steps to Justice website. Other helpful resources, if you are representing yourself, is the NSRLP project, the National Self-Represented Litigants Project. There's a resource tab there. It talks about a lot of things such as Mackenzie Friends, and really there's checklists there. It is a great resource to tap into. That concludes the basics of family law for the very first matter. Coming soon, though, there are going to be a number of empowering courses for good parents to navigate the high conflict divorce. That is what I have many, many years of experience in. Some of the courses that I will set up are the Narcissist in Family Court, Mediation, Arbitration, and the Narcissist, Parent Alienation, How to Stop the Claims Before They Take Hold, Protecting Your Children in Family Court in Canada, and high-level interview questions to hire the right lawyer. If you like this video, I would appreciate you press like. If you're watching on YouTube, press subscribe as I download more and more content. You can visit me on the website, Instagram at Spin Divorce, or reach out to me via email at spindivorce@gmail.com. My name's Lorraine Lawson. I am wishing you an empowered journey moving through this transition from your old life to your new life.